Attorney Harry Roque repeatedly made representation of his commitment to submit a number of documents because of his assurance and commitment that he will be forwarding the same. To this date, we have not received any of those. I therefore manifest instead this reasonable warning for our resource speaker to comply with the said subpoena. And I wish to manifest, Mr. Speaker, that every time a question is propounded to Cassandra Leong, Attorney Topacio whispers to the client. And I have no other reasonable conclusion except he is indeed supplying already the answer, far from advising a client.
Enzo-recto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
Mr. Chair, we are in possession of the letter of Attorney Harry Roque seeking for excuse for his absence in today's committee hearing. Considering, Mr. Chair, that we have precedent already where the resource speaker misrepresented as to the truthfulness of the fact of the schedule of his hearing, may I move, Mr. Chair, that the veracity of the truthfulness of the facts cited in this letter be verified by the committee secretary. So move, Mr. Chair.
There is a motion for the committee secretary to verify information as stipulated in the letter of Attorney Harry Roque. Duly seconded, and hearing no objection, the motion is approved. Comsec, please comply.
Second, Mr. Chair, in our last lengthy hearing, Attorney Harry Roque repeatedly made representation of his commitment to submit a number of documents that includes his SALN from 2016 to 2022, DOS of multinational subdivision with tax returns, trust agreement, settlement of estate and tax returns, docs submitted to SEC pertaining to the transfer of shareholdings from spouses Roque to Attorney Percival Ortega, and ultimately the ITR of spouses Roque and Biancham Corporation. I lament, Mr. Speaker, that while we waited for the submission of these documents, because of his assurance and commitment that he will be forwarding the same, to this date, we have not received any of those, granting only for the sake of discussion that indeed he has engagements in the international arbitration in Singapore today. I do not see any reason why he will fail to submit those documents in today's hearing. Nonetheless, Mr. Chair, I understand that the committee has issued already a subpoena as earlier manifested in our morning session. I therefore manifest instead this reasonable warning for our resource speaker to comply with the said subpoena.
The statement of Congresswoman Luistro is noted, and the COMSEC is directed to follow up the requests of Congresswoman Luistro pertaining to the documents required of Attorney Harry Roque. Thank you, Congresswoman Luistro.
Third, Mr. Chair, the committee is in receipt of the letter from Cassandra Leong, represented by Attorney Topacio, claiming, among others, that her client opted to decline to testify, invoking the right to remain silent and/or the right against self-incrimination. I deeply lament this action coming from the resource speaker, Mr. Chair, because we will remember that even prior to the creation of the Quad-Comm, various resource speakers have been mentioning already the name of Cassandra Leong. And it is really unacceptable if we will allow in today's hearing that the resource speaker will remain silent, will not answer our questions under the guise of his right against self-incrimination. In the same letter, Mr. Chair, they even cited the case of violation of visa law of the Bureau of Immigration, as well as obstruction of justice, as the case is filed already against the resource speaker. making an impression, Mr. Chair, that we cannot raise question to her anymore. With that, Mr. Chair, please allow this representation to lay down the parameters when the right against self-incrimination may be availed and when they may not be availed. Mr. Chair?
Please proceed.
In the case of Rosete versus Lim, this was decided June 8, 2006. There are two requirements before the right to self-incrimination may be availed. One, there must be an identifiable crime. And two, the resource speaker is probably guilty of the said crime. Second, Mr. Chair, in the case of Sabio versus Gordon, October 17, 2006. Right to self-incrimination can be availed only when the same is being invoked in relation to the question which is being propounded. In other words, this cannot be claimed as a blanket privilege. When there is a question, the resource speaker has to invoke and the chair has to resolve. Third, Mr. Chair, the case of De La Cruz versus People, July 23, 2014. The right to self-incrimination applies only to testimonial compulsion. In other words, object evidence is not covered by the right against self-incrimination. Fourth, Mr. Chair, is the Office of the Court Administrator versus you, which pronounces it does not cover legitimate inquiry if non-criminal matters. In other words, only question which pertain to crimes is covered by the right against self-incrimination. Fifth, Mr. Chair, is the case of People versus Aison, July 1989. The right to self-incrimination is not self-executing or automatically operational. In other words, it needs to be invoked. Otherwise, it is considered waived. Sixth, Mr. Chair, is the case of Arnold versus Nazareno. It was ruled that the right cannot be invoked if the same would be inconsistent to the witness' prior claim that the transaction were legal. If there is a prior statement already that the transaction is legal, all the subsequent questions pertaining to the same are not covered anymore by the right against self-incrimination. And last, Mr. Chair, the case of People versus Gonzo, which is likewise the ruling in the case of Senate versus Ermita. A witness is not relieved from answering merely on his own declaration that an answer might incriminate him, but rather, it is for the trial judge to decide. By analogy, Mr. Chair, in our today's inquiry in aid of legislation, the discretion belongs to the chair of the Quad Committee. Chair, the reason why I started our hearing with the parameters on the use of right to self-incrimination is to guide our resource speaker as to when they can be availed of and when they cannot. And as far as this representation is concerned, Mr. Chair, we have two elements before they can avail of the right against self-incrimination. One, there must be identifiable crime. And two, there is the probability that the resource speaker may be convicted of the crime. Now at this point, Mr. Chair, may we ask Ms. Cassandra Ong, nung tinanong ka ba ni Honorable Dan Fernandez, kaninong away ang iniiwasan mo? Ano bang krimen ang iniisip mo na baka ikaw ay madamay? I wish to believe that when an attorney is supposed to advise a client, he's supposed to talk to the client, let us say 5 minutes, 10 minutes, but if he does it in every question which is being propounded to the resource speaker, it seems to be he is supplying already the answer to the resource speaker. A situation which we do not allow here in the inquiry in aid of legislation. And I wish to manifest, Mr. Speaker, that every time a question is propounded to Cassandra Leong, Attorney Topacio whispers to the client. And I have no other reasonable conclusion except he is indeed supplying already the answer, far from advising a client.
Thank you, Congresswoman Luistro. Naintindihan mo ang sinabi ni Congresswoman Luistro?
May hulanong salita na ang ibig sabihin dito ay ang pagkakaisa.
Bunyog Party List.
Halika na, bunyog party list ka na. Halika na, bunyog party list ka na.
Sa susunod, ang atinang suportahan, Bunyog Party List, nagtataguyod ng katotohanan, lumalaban para sa